Welcome, America, to our webinar, U.S. Law Shield Live. I'm Sam Malone, your host in Houston, Texas. Thank you so much for joining us, members and non-members and soon-to-be members of U.S. Law Shield. Our topic, the law of deadly force and justification during civil unrest. And man, there's a lot of civil unrest going on. Turmoil, looting, rioting, a pandemic scare on top of that. Responsible gun owners, like you and I, are experiencing fear, uncertainty, anxiety, right? The problem is that poor or incorrect decisions that are made can lead to negative consequences for legal gun owners. So what we're going to do during our live webinar across America is to walk you through what you need to know about the legally justified use of deadly force. Hopefully you'll have a clear understanding of what the legal aftermath will be if you're forced to fire. And that's why it's so essential to become a member of U.S. Law Shield. I've been a member for years. Of course, if there's an event, you pay zero attorney's fees. And more importantly, you have 24/7 access to attorney-answered emergency hotlines for members only. And that 24/7 line will be an attorney from your state. So if I were to call, I would get an attorney from Texas. You'll get member-only offers, there's events, there's discounts, there's FaceTime with attorneys. Bottom line, U.S. Law Shield's the leading legal defense for self-defense in the country. Of course, during our webinars, they're famous because we take the questions and take them right to the independent program attorneys across America. We start with Edwin Walker. He's in Texas, and Mike Jeremita making his first visit from just outside my home city of Philadelphia. Edwin, welcome aboard, sir. How you doing?
I'm doing great, Sam. It's always great to be here with you and with all the U.S. Law Shield members that are tuning in.
It's amazing. And Mike, your first time from my backyard in Philly. Welcome aboard.
Thank you for having me, Sam.
All right, Mike, we'll start with you. Obviously, this is not a fun topic. It's a scary topic. But the members of U.S. Law Shield and the soon-to-be members need to know the facts. First of all, the advice you'll be giving, you're in Pennsylvania, and Mr. Edwin is in my backyard of Texas. But what are some of the basic factors that we need to know that have to be in place for me to be legally justified in using deadly force? Mike.
Sam, one of the most important things that people need to know is that when using deadly force, you have to be justified in knowing that you're preventing something that's immediately a threat. I think that's one of the most misconceived things about using deadly force. In Pennsylvania, for example, deadly force must be immediately necessary to prevent death, serious bodily injury, kidnapping, or rape. In New Jersey, where I also practice, they say immediately necessary to prevent death or substantial bodily harm, which would include aggravated sexual assault. Now, the exact perspectives might not be the same from state to state all over the country, but the bottom line is the law never requires you to allow somebody else to kill you or to brutally beat you to the point where you'd be disfigured, you'd have permanent loss of limbs or of organs. But you have to understand the threat must be immediately necessary. There's an imminence requirement, and there's a big difference between protection and revenge.
Now, Edwin, let me ask you, have any of the events changed when you have rioting, looting, civil unrest? Have the factors changed that Mike was just talking about?
Well, no, they haven't changed. They're still the same. However, with regard to the use of deadly force, it does have to be reasonable. And most states define reasonable the same way. Basically, that an average ordinary person in the same or similar circumstances would have acted the way you did. Now, obviously, with us turning on the televisions every single day and seeing the rioting and the looting and the burning and the assaults that are going on, your jury, a jury that is going to sit in judgment 6 months, a year and a half, 2 years from now, they're going to be replaying those images in their head, or at least a good defense attorney will force them to replay those images in their head so that they will put themselves in the position of a reasonable person. That reasonable person, of course, ultimately being your client. You want your client to be the reasonable man. And one thing that I would tell people out there that in order to get an exact sort of an exact pinpoint explanation of the laws in their state, that they should reach out and contact their own independent program attorney, because while the jury will sit and judge what is reasonable, what an ordinary person would feel is reasonable, there are many states like Texas which go ahead and create legal presumptions for people who use force and deadly force in particular places or particular circumstances or in response to particular types of crimes. And so that becomes a very, very powerful tool, because the court will actually instruct the jury that it is the law of that particular state that they are to presume that the individual acted reasonably if they had a reasonable belief that they were in one of these circumstances. Most states have the circumstance of being in your occupied habitation, your occupied vehicle. Here in Texas, we actually extend that to businesses as well, your occupied business or place of employment. And so that kind of anticipates things like looting. If you're in your business and they're coming through the door, they're doing it forcefully, unlawfully, you're going to be given that legal presumption.
Amazing. Hold on, Mr. Walker. Let me jump to Mike outside of Philly. Mr. Walker talked about looting of businesses in Texas. How do things stand in? But we were just watching some B-roll from my hometown of Philly. It tears my heart out, all the looting. Walk us through that, Mike.
Like Edwin said, the law itself may not change. But with these becoming common practice, having things like looting, things like rioting, and these violent episodes, the frequency at which the average law-abiding citizen has to make a split-second decision as to whether they need to defend their own life or defend their well-being, those are going to be far more frequent in the weeks to come from what we've seen so far.
With you, Mike, in Philadelphia. Mike Jermita, by the way, one of the independent program attorneys like Edwin Walker, experienced professionals. These are the men, and you'll see in women in the next segment, who answer that 24/7 attorney-answered emergency hotline. Mike, I'm a responsible gun owner. I'm trying to avoid areas of looting and violence and rioting, but I accidentally and somehow find myself in the middle of it all. What should I be aware of in Pennsylvania?
There are a couple of things that you should be aware of. Number one, as my friend Jose Morales of Philly Firearms Academy often tells people, not every problem is a nail that requires a hammer. So I encourage people to have layers of defense in these types of situations. Second of all, understand when your state law imposes a duty to retreat. Generally speaking, we have a duty to retreat if we can do it with complete safety. But there are circumstances where statutory law will get rid of that duty to retreat altogether. Stand your ground being a very common doctrine that does this in many different states. Now, make no mistake about it. The media blows this well out of proportion and makes it sound like stand your ground is some license to kill. It's just far from it. All it does is, in certain situations, it eliminates or impacts that duty to retreat, which you generally have if you can do it with complete safety. Finally, understand that when you're defending yourself and you're thinking about deadly force, preventing death or serious bodily injury in those kinds of circumstances, these situations can arise when the other person, the aggressor, is not necessarily armed. Suppose there's a group of people attacking one person. Suppose they have an instrument that's not a firearm, but something that's readily capable of causing death or serious bodily injury. We have reports in Philadelphia of men throwing bricks at people, groups of people coming around with pipes and attacking people. I know the fake news doesn't show this stuff, but look at the first responders' reports. This is what you're going to see. Amazing.
Edwin Walker, you're in Texas. Where I am right now, is there anything we need to know? We, as responsible gun owners, avoid, but we get stuck in the middle of a violent situation.
Right. Well, one thing I like to tell people, one thing I like to remind people is that your license to carry a handgun is your license to carry a handgun and your right to self-defense applies whenever trouble comes after you. That is certainly not a license for you to go looking for trouble. And so you absolutely should avoid those, any type of circumstance that may present that danger. Now, that being said, Texas does have a no duty to retreat law, which means that basically if you do find yourself in a place where you have a legal right to be, which is basically any place where you're not a trespasser. So you have a right to be at the store. You have a right to be in the parking lot. You have the right to be in the park. You have, any place where you're not committing the crime of trespassing, and you're not committing any other crime. Then the law says that the police and the prosecutors cannot come behind you and judge you in terms of, well, you knew you shouldn't have been there, so therefore, we're saying that it wasn't reasonable. That's going to go into our argument of reasonableness. Our Texas no duty to retreat law prevents any kind of second guessing like that. And also, what I wanted to add to what Mike said is that with regard to the standard of using deadly force, you have to use it whenever you're in fear of death or serious bodily injury. And we've seen increasingly that it could come at the hands of something that is not a firearm. But the law says that any object can be a deadly weapon depending upon its manner and intended use. And so, I don't know if the viewers are familiar with the New Mexico video, the New Mexico shooting that happened earlier this week. But the man appeared to be in danger of getting his head bashed in with a skateboard. So ordinarily, skateboard, not a deadly weapon. However, when you use a skateboard to try to take the top of someone's head off, then yes, in fact, it does in that circumstance become a deadly weapon. And so be wary of that. Also, most of these attacks that we've seen on the news have come with groups of people, and that goes into that's a circumstance that we call disparity of force. And so, in a disparity of force issue, that is certainly a very, very pertinent circumstance that a jury would need to be informed about. That goes into their decision as to your reasonableness in using deadly force.
You're watching our webinar across America, U.S. Law Shield, the Law of Deadly Force and Justification During Civil Unrest. I'm Sam Malone, our independent program attorneys right here. Let me get back to you, Mr. Walker, on the question of all the new gun owners out there. Obviously, during the pandemic virus scenario, there was, quote, a gun run, as many ran out justifiably to purchase firearms, maybe for the first time. My question to you is, they're probably wondering exactly how to use these guns in self-defense. If they're ever forced to make that decision, what would you tell them? What should they be aware of ahead of time, these new gun owners, Mr. Walker?
Well, if you are a new gun owner, one thing that I would say, just for the safety of yourself and those around you, is please go to the range and learn how to operate it properly. Learn how to operate it while you're under stress. Learn how to operate it in the presence of other people. Learn your basic rules, that you never point a gun. You always assume a gun is loaded. Never point it at anybody. Always keep your finger off the trigger until you ever use it. So learn the basic safety. With regard to, learn how to use it. As far as learning when to use it, that's why U.S. Law Shield is such a great resource, because your lawyer is always there to answer your questions about when and how to use it. Now, the law is accessible to everyone. It is, on the internet. A lot of people say, well, I can't really understand it. Obviously, that's where we obviously advocate that a lawyer comes into play. But one thing that I would caution is, don't rely on Facebook lawyers. Don't rely on the media. Don't rely on blog posts. Get your information from a reliable source like a U.S. Law Shield program attorney, or some other attorney or legally verifiable source. Go straight to the code, learn what the law is. Don't rely on learning it from non-lawyers. Certainly don't rely on learning it just strictly from somebody's interpretation on the internet.
Edwin Walker, independent program attorney. Let me jump over to Mike Jeremita in Philly. Mike, these new gun owners, and I'm sure there was a gun run there in the Keystone State and next door in the Garden State. What should these first-timers know from the perspective of an independent program attorney in Pennsylvania, in Jersey?
Absolutely. Number one is firearm safety and training. So go ahead and get yourself some kind of a class. Even virtually, we see these things happening right now during the pandemic. Pennsylvania is one of the states that do not require any kind of course or competency testing for a license to carry firearms. Many other states are like that. So don't let the anti-gunners win and have an accident happen or something bad happen where they go back and say, see, that person should have been training. Take it upon yourself. Don't let the government force us to do these kinds of things. Second is know the law inside and out. Presumably you're buying a firearm because you want to protect yourself and your loved ones. You want to enjoy your life with your loved ones. You don't want to end up behind bars for the rest of your life because you didn't know the law before you used that firearm.
Independent program attorney Mike Jeremita in Philly. Staying with you, Mike, during our U.S. Law Shield webinar across America. Let's transition in the movies. After the shooting, the good guy gets pats on the back and probably some pretty gal kisses him and maybe a parade. It's probably not like that in real life, I'm assuming. Walk us through, then we'll get to Edwin, what happens, for instance, in Pennsylvania after the shooting.
Yeah, that is just that. That's the movies. That's fantasy. That is not reality. People think that if they use their firearm because they have a license to carry, the police are going to show up and pat them on the back, say, great job, you got the bad guy, nothing else to see here. No, you're going to be scrutinized. And we see this happening time after time in these shootings that are ultimately publicized, where maybe people in the public would say, hey, I don't necessarily see anything wrong here, but you've got a prosecutor who's going to take the ball and run with it. You've got a police department. Their job is to investigate this as if it's a crime. Their job is to charge this crime if they see it there. So you have to understand that you're going to be interrogated, and just because the police are friendly does not mean that they are your friend. You have to lawyer up and shut up, as we tell people out here. Invoke your right to silence, invoke your right to an attorney, because you may be making statements that'll ultimately put you in jail. You don't want to do that.
Walker, that was a great line from Mike Jeremita. Just because the cops are friendly doesn't mean they are your friends. Talk about the aftermath of a shooting to legal gun owners like myself.
Oh, yeah. Keep in mind that the police, the whole good cop, bad cop thing is a reality. The police are lawfully allowed to deceive you. The police are lawfully allowed to use any information that they gather from you via any means, including after they give you your right to remain silent and you invoke it. But then you decide, I just can't hold it in anymore. I got to talk. All of that can then be used against you. Keep in mind also that a lot of patience is required. So in the event that you do find yourself in the legal system, it does not wrap up in an hour like an episode of Law and Order. Don't get anxious. Don't give any evidence against yourself. And also, you have to remember, I know that a lot of this, or pretty much all of this unrest that we've gone through has been spurred by police actions. Whenever a police officer, it is the standard around the country that whenever the police officer is involved in a use of force or deadly force situation, they are given, by procedure, they are given 48 to 72 hours under which they are not required to make a statement about what happened. And so just remember, as an ordinary citizen, you're governed by the same rights. You have the right to have a 48 to 72 hour cooling off period as well. And just because you don't speak to the police officer, that cannot constitutionally be used against you in court. So take full advantage of that.
I did not know that. See, that's why it's great to have access to the independent program attorneys of U.S. Law Shield, the experienced professionals. And as a member, like I've been a member for many years, flash logo, 24/7 access, even during the holidays, July 4th, Labor Day, Thanksgiving, and you'll be talking to an independent program attorney in your state. Staying with you, Mr. Walker, and we'll talk about Texas. I'm a proud longtime member of U.S. Law Shield, and you guys have personally taught me the important things to say, the right things to say. In a 911 call, it's essential. Explain why saying the right thing during a 911 call can affect the future.
Yes, well, on a 911 call, the only thing you're required to tell them is the who, what, and where. Who you are, what you need, and where you're at. And that's it. We always advise, though, that since you are only allowed to use force or deadly force in a situation where you are responding to the unlawful use of force or deadly force, you might want to go ahead and start the phone call with the crime that is being perpetrated or has been perpetrated against you. So I'm calling not because I shot somebody, not because I had to pull my gun on somebody. I'm calling because somebody tried to carjack me. I'm calling because somebody tried to break in my house. I'm calling because somebody tried to rob me at the gas station, that sort of thing. So tell them what crime you're calling about, the crime that you have responded to. Tell them who you are, where you're at. Always give some sort of identifying piece of information about yourself, as in what you're wearing, so that the police don't drive up and immediately assume that you're the bad guy. Let them know right off the bat that you are the 911 reportee. And then, once they get there, if they start asking, hopefully by that time you've had an opportunity to contact your U.S. Law Shield independent program attorney on the hotline. And certainly what you don't want to do is just start rambling on, giving them information that they don't ask for, and certainly don't give them any information that contradicts any of the physical evidence that's present at the scene.
Yeah, let me jump over to independent program attorney Mike Jeremida in Philadelphia. Yeah, talk about that, the 911 call after a legal self-defense move by a member of U.S. Law Shield, for instance. What are some of the mistakes as well that they make on a 911 call, Mike?
Saying too much, and people don't understand the importance of this 911 call. That is going to be Exhibit A in a case where they're trying to put you behind bars for the rest of your life. And people don't realize that when they're making that call. They don't think about it ahead of time and therefore prepare appropriately. You have to understand is that you could be saying something incriminating during that call. You were in no state of mind to be accurately and coherently conveying exactly what happened or the finer details of the interaction. So understand that in the aftermath of a critical incident, you're going to have physiological effects. If you read a book called Grossman on Combat, talks about all these different things like time dilation, racing thoughts. You don't remember details about what just happened to you. So keep it simple, like Edwin said. Have something prepared that you're going to say in the event of an emergency. Tell them you've been the victim of a crime. And after you've given them the necessary information, shut up.
Mike, well said. Now on that topic, I'll stay with you in Pennsylvania. Walk us through what happens. Kind of give us a timeline. Someone, fires the weapon and the police come. Of course, there's investigations, there's court. Walk us through kind of in a snapshot of what happens, what we can expect.
Yeah, so there are a lot of different things that happen along the way. Once they determine that they will be bringing charges, you're going to be brought before a judge at what they call the preliminary arraignment. At that time, they'll be discussing if there are any bail options available, if they're going to, what the conditions of bail would be. And at that point, they're also going to set what they call the preliminary hearing. So there's a gap between then and when they determine whether the case will move on. Preliminary hearing, you have a very, very low burden. Basically, all they have to show is that there's some evidence that a crime was committed and the defendant was the one that did it. And as one of our Law Shield attorneys out in Pittsburgh, Brian Sitchko, often says, for a simple assault, all they have to do is bring someone on the stand to say, that guy punched me in the face, and point at the defendant. That's all they need to get past that preliminary hearing. So then if the charges get bound over, we go to what I like to call big boy court, up at the Court of Common Pleas. Then you're going to, at that point, have your first opportunity to review discovery, all the evidence they plan to bring against you, some of the witnesses they plan to bring against you. Keep in mind, you've been in the dark about all this stuff leading up to that point. And then after going through the discovery process, you might have some motions that are involved. I've got a motion that's coming up in a Law Shield case. We're coming up on a year since the charges were brought. We're just getting to the pre-trial motions. This is a lengthy process if we're going through trial.
Edwin, jump onto that story about what we can expect from, I hate to say it, but start to finish, as Mike was saying, a year just to get to that point. Edwin.
Yeah, here in Texas, we use the grand jury process. And so while somebody can be arrested and have a charge filed against them, it is not absolutely necessary that they be charged. Most cases where they believe that a felony's been committed, especially if somebody's been killed, will go to the grand jury. And in Texas, no felony can proceed without a grand jury indictment. Unfortunately, it actually sounds like the grand jury process is even less formalistic than the preliminary hearings in Pennsylvania, because the prosecutors don't even have to present evidence. All they got to do is get up in front of the grand jury and basically recite their story. Their witnesses don't have to be present. They don't have to be sworn. There doesn't have to be any verification. The prosecutor can simply sit up and say, yeah, this person, Joe Smith, killed this other person, John Williams. And he did so with a firearm. That's it. And the grand jury will go, okay, and then you're indicted. That's why it's often said that a prosecutor can indict a ham sandwich if he chooses to. So then at that point, it proceeds basically through, like Mike said, the discovery process where the state has to reveal all of their evidence to you. It is unconstitutional for them to hide evidence. It's absolutely a constitutional violation for them to fail to disclose evidence that is favorable to the defendant. So once the state has revealed all their evidence, then the court would feel comfortable setting the case for trial. And then any kind of issue involving the admission of evidence would then be ruled on by the court. Here in Texas, one thing that does vary state to state is that the judge is not the gatekeeper with regard to the issue of self-defense. The Texas law is very clear that if there is even a small bit of evidence that shows that the defendant acted in self-defense, then the jury is given the authority to decide that issue. And so the jury is given the authority to decide that issue. So the judge cannot prevent the jury from hearing the self-defense. The judge does not act as a gatekeeper to the issue of self-defense. The judge makes no preliminary rulings whatsoever. That is an issue that solely lies within the realm of the jury.
Love it. Great info on our webinar across America. Edwin Walker, Mike Giramita, independent program attorneys with U.S. Law Shield. Thank you for taking the time to join us on our webinar. And you can see how essential it is to become a member. I've been a member for years, whether you carry for self-defense, you like to sport shoot, you're a collector, you have guns in the home, whatever the reason, the membership is essential with U.S. Law Shield. First of all, if there's an incident and you need the attorneys, 0 attorney's fees, but you also get FaceTime with attorneys when you're a member. There's events, there's discounts, there's member-only offers. Bottom line, 24/7, attorney-answered emergency hotline for members, and it's the attorney will be in your state. So I'm in Texas. Done. I get a Texas attorney. As always, U.S. Law Shield's leading legal defense for self-defense in the country. More Q&A coming up. I want to get to Dr. Hamasfar, who's always chock full of information in terms of a gunshot wound. If it happens, what do you need to know? What should you be doing before help arrives? More questions next.
Members, if you're anything like me, you fear the day you come home only to discover your front door smashed in. But because you're a Law Shield member, you've prepared for this very moment. Your pulse races as you draw your gun, ready to confront any threat to you or your family's safety. However, as you hear the approaching sirens in the distance, you soon realize that the thief is long gone, and all you're left with is that crushing sense of violation and vulnerability. And even though you never had to confront the criminal face-to-face, you're still going to have to face the nightmare that follows your gun being stolen. Because let's be honest, not all criminal incidents involve acts of self-defense. But here's the good news. We've created a brand new membership protection called Gun Owner Identity Theft Coverage. That, when combined with your current Law Shield membership, not only protects you if you act in self-defense, but also if you end up enduring the nightmare of having your gun stolen. How does it do this? First, by educating and preparing you ahead of time to ensure you have all the proper documentation in order so you're not going to be left scrambling after the fact. Second, we'll assist you in alerting the proper authorities that your gun has been stolen so you're not charged with a crime you didn't commit. And third, if you're forced to hassle with the police, or worse yet, defend yourself in court, our independent program attorneys will fight for you until the gavel bangs and your freedom is restored.
Well, good evening. Let's talk a little bit about life-threatening trauma care during times of civil unrest, because frankly, there are a lot of people getting hurt out there. And unfortunately, up until very recently, we knew if we called 911, people would come to help us very quickly. And thanks to the events of the last 2 weeks, we now know that's not always true. Systems get overwhelmed, streets get crowded, and fire EMS may not be able to help us. So when seconds count, it may be hours before somebody can come to get us. And that's important because time is critical in treating injuries. The military has looked at the injuries that can cause death, but which, if treated correctly, may actually allow somebody to survive until they get to the hospital. And those three injuries are massive arterial bleeding, which can kill you in about 3 to 5 minutes, airway obstruction, which will kill you in about 6 to 8 minutes, and chest wounds, which will kill you in about 20 to 30 minutes. So what we're going to do today is focus on bleeding, because the massive arterial bleeding is what kills you first. And what are we talking about with massive arterial bleeding? That's when you walk up and you see somebody and blood is just gushing out. It looks like somebody's turned a faucet on. It's just flowing all over the place. Pools of blood-soaked clothes. It's obvious that if something is not done very quickly, this person is going to bleed to death. That's massive arterial bleeding that's life-threatening. And when you have to stop that and stop it very quickly. And the fastest way to do that is with a commercial tourniquet. There are a lot of different tourniquets on the market, but there are only several that really have the science that show that they work. One of these is called the TMT. Another one is called the Soft T Wide. You also have the SAM XT, and you also have the Combat Applications Tourniquet or the CAT Tourniquet. They're all excellent. The CAT tourniquet's been around the longest and has the most research done on it. But the key is get a tourniquet, know how to treat these injuries. But if you don't have a tourniquet around, can we make a tourniquet? Well, here's the harsh reality on improvised tourniquets. They have very high failure rates, between 30% and 100%. Unlike what you see in the movies, putting a belt around a leg or tying a rope around a leg will not necessarily stop bleeding and save somebody's life. And in fact, when these improvised tourniquets are used incorrectly, they can actually increase the blood loss. So if you want to learn how to use an improvised tourniquet, do the research, learn how to make an improvised tourniquet. But remember, they take time to make. The whole time you're making the tourniquet, that person is bleeding out. Now, let's take an algorithm on how do we approach somebody who's bleeding and what do we do about it. Well, first of all, when you come up on them, take a look, identify the bleeding. And if you're looking for massive life-threatening bleeding, you're looking for blood pumping out, pools of blood, blood-soaked clothes. And if you have that, the next question is, well, do I have a tourniquet? If I have a tourniquet, let's get the tourniquet on. And it's the commercial tourniquet that has the highest rate of success and it goes on the fastest. Now, if you don't have a tourniquet, what are your options? Well, one of them is to do an improvised tourniquet, but we've already discussed the problems with that. The other option is to use direct pressure, either at a pressure point, either on the wound or at a pressure point between the wound and the heart on one of the major arteries, and try to slow the bleeding down when somebody gets a pressure dressing on that wound. And then once it's on, you really want to sit there and hold pressure on it until the bleeding stops. That may take 10 to 20 minutes, but you have to keep the pressure there until the bleeding stops. And that's the way you address life-threatening bleeding. Now, what if it's just a really bad wound where it's a bad cut and it's kind of oozing and you've got some bleeding going on, but nothing really pumping out? Well, that's non-life-threatening bleeding. And non-life-threatening bleeding is not going to kill somebody in 3 to 5 minutes. Therefore, we don't deal with it right away. What we're concerned about are the things that will kill us. That's the airway obstruction and chest wounds. So you deal with those two, and then after you've taken care of that, then you cycle back through to the non-life-threatening bleeding and use a compression dressing with a direct pressure and then wrapping a dressing around it. And that's how you take care of the massive bleeding. Now, what have we learned from all of this? Basically, there are 3 preventable causes of death that can occur before somebody gets to a hospital or gets to medical care, and these causes are all from penetrating trauma. It doesn't matter if it's a gunshot wound, a knife wound, a motor vehicle accident, a fall from a tree. These things will kill you. And it's massive bleeding in 3 to 5 minutes, airway obstruction in 6 to 8 minutes, and a chest wound in 20 to 30 minutes. We've talked very briefly about bleeding, but really what you need to do is get into a course, learn how to treat these issues, learn about the types of medical equipment that you need, get reputable medical equipment, and learn the skill stations and learn how to do this stuff. And let me give a shameless plug for the U.S. Law Shield Emergency First Aid for Gunshot Wounds course. It's a great course. goes into great detail on all of these things, and you'll come out very well prepared. But the point is, you need to learn how to take care of these issues, because if it's not civil unrest, it may be that you're out in the middle of the woods. But unfortunately, these life skills will carry over to the rest of your life, whether it be an auto accident where you're there before somebody else, whether it's your daughter that runs and falls through a plate glass window. These skills can be applied to any life-threatening situation in which there's massive bleeding, airway obstruction, or if you have a chest wound. So get the knowledge, take the course, become that first responder, that immediate bystander that knows what to do in these times. Because it may not be the life of your loved one, it may be your own life you have to save, or the life of a bystander.
As a U.S. Law Shield member, you already enjoy the best coverage in America. And you can strengthen that protection through our most popular add-on, multi-state coverage. Multi-state extends the service you already enjoy in your home state to protect you in all 50 states, Washington, D.C., and Puerto Rico when you're traveling. And the best part, this peace of mind can be yours for just $2.95 a month. So log in or call us to add multi-state coverage to your Law Shield membership today.
Welcome back to our live webinar. I'm Sam Malone in Houston, Texas. Great work, Dr. Hemisfar. Our topic, of course, through our entire webinar, the law of deadly force and justification during civil unrest, the turmoil, the pandemic scare, the looting, the rioting. Responsible gun owners like us are experiencing a lot of fear and uncertainty. But remember, during this webinar, we want to make it clear that poor or incorrect decisions can lead to negative consequences for legal gun owners. That is why it's so essential to learn, to watch, to replay it again later. Most importantly, become a member, U.S. Law Shield. So should there be an incident, you've got the experienced professionals, the independent program attorneys standing by 24/7 from your state. USLawShield.com. Available right now. Hop on the website or just wait a couple more minutes so I can get to the Ross and Rachel of independent program attorneys, longtime friends Emily Taylor and Richard Hayes, both independent program attorneys in Texas. And this is when we get to your questions. Emily, thanks for joining us.
Thanks, Sam. I think you might need to update your reference there a little bit.
I'm an old guy. That's the best I can do. Mr. Hayes, as always, former prosecutor from Galveston County, Texas. Thank you as well for joining us.
Absolutely, Sam. And I think Emily's more of a Phoebe, if you ask me.
That makes me a Gunther, so that's okay. Here we go. These are the questions that have been sent in previously. Hal M. wants to know, what are the legal differences during civil unrest versus normal times? Emily, what are the legal differences during an unrest that we've seen on television and the news?
Well, most often, it's not going to change what you can and can't do to defend yourself. But there are lots of other little ways where it plays in. I mean, everything from increasing penalties for people who commit crimes during a state of emergency to just your general reasonableness and analysis. Because, as you know from listening to Edwin and Mike, a lot of this, virtually all of it, unless you're given a presumption, comes down to your reasonable person. You've got to convince the jury that you acted as an ordinary and prudent person would. And they're going to get to take into account what's happening in the world and why that might put you on edge, why that might be particularly scary, what's been happening in your neighborhood. That's all going to come into play. So although the law may not necessarily change, your rights are substantially altered because of that reasonable person standard and because of the factoring in of the world at large.
Richard Hayes, independent program attorney in Texas. Add to that all these incidents going on. You are a prosecutor. How does that play in to the courtroom event?
Well, I will tell you, like Emily said, it may not have changed the law. It is definitely going to change how a jury views your actions. So if you are, and they have been given an ample supply of imagery to fill their heads with, how is this going to impact the person on the defensive end? So it's the same thing that we have when people talk about, defending yourself at nighttime as opposed to daytime. It's because we all know that there's some ominous, you can't see people's hands, that you don't know how many people there are, It's the same thought pattern goes behind that as goes towards defending yourself during civil unrest. These situations are extremely volatile. They can turn on a dime. These crowds of people are extremely dangerous. And so a jury is going to be allowed to put themselves in your shoes and say, all right, when this person was acting in defense, if they were using force or deadly force, what were they responding to? And a jury, I can see a jury being very sympathetic towards that.
Talk about turning on a dime. Staying with you, Mr. Hayes. Gloria has a question that I think most people have run through their mind. Can I legally display my weapon to get a crowd of protesters who are blocking my car to move? And we've seen this in many cities. Protesters, whatever, run out and illegally block traffic. You've got to get to work or the hospital or something. Can you go and unholster the weapon and wave it around, Mr. Hayes?
It's a very, very frightening scenario. And I will preface it with this. What the law is looking at is lives and things. Okay, what are we defending at its core? If the only thing that's happening is you're being prevented from traveling where you want to go, if that's the only risk, then probably not. That would probably not be justified under the circumstances because no person is really in danger. But like I said, these situations are extremely fluid. One thing could change, and yes, what Gloria is asking could be the absolute right thing under the circumstances. But just simply blocked, just being held standstill. Mike Jaramita was talking about this. Every self-defense claim, every good, successful self-defense claim must contain an element of immediacy. That when you're acting in self-defense, it's because you have to act right now without delay. There's not time to call the cops. You have to do it right now. And being stuck in traffic, while inconvenient, we all got places to go. That probably would not be a situation where you'd be justified in displaying a weapon. But like I said, these things can change very quickly, and my answer would change depending on what's going on.
Emily Taylor, obviously, it's a very fluid kind of answer, but imagine you're surrounded. It happened here in Houston when people blocked traffic to protest. Glorious, and I get it. You see it in a lot of movies or a lot of TV shows, brandishing the weapon. What's your 2 cents?
Mm-hmm. Yeah, well, I think there's probably a lot of people out there who are listening who are kind of saying to themselves, so you're telling me that someone is going to try to break into my car, they've got a baseball bat, they've got a brick, and I can't defend myself. And that's where the situation, because these are fluid situations, that's where we change. Because in most states, not every state, but in most states, your vehicle is also your castle. So when you are inside of your vehicle, if someone makes an attempt to get inside that vehicle or to get you out, that's when you're going to be given a presumption that your use of deadly force is reasonable. Again, that's for castle doctrine states where a vehicle is part of your castle, but most states have that. So when we change the situation from what Richard was describing, which is just a simple block traffic, inconvenient, to a situation where human life is threatened, where someone is trying to get into your car, maybe they've got a skateboard, baseball bat, brick, maybe a firearm, whatever it is that's going to get them into your car, at that point, you get to take advantage of those elevated rights because then we're talking about lives, not just things.
You're watching U.S. Law Shield webinar, The Law of Deadly Force and Justification During Civil Unrest. Independent program attorneys in Texas, Emily Taylor and Richard Hayes. Emily, staying with you, and we go back to the crowd has blocked a car in, and you're giving advice from a Texas independent program attorney. Joe, and you can put his question up on the screen, writes in, how does the law apply if I have to use my vehicle as a weapon to escape from a violent protest? Emily.
Yeah, so deadly weapon, it's got a different definition in every state, but they all amount to virtually the same thing, which is a weapon that is capable of causing, or in its manner of use, does actually cause or is intended to cause serious bodily injury or death. So can a vehicle cause serious bodily injury or death? Yes, of course it can. So that places that vehicle in the realm of deadly weapon, which means if you are going to use it as such, you have got to be justified to use deadly force. So, the situation Richard's describing where you're just looking at someone blocking your path, probably not. A situation where someone's standing in front of your vehicle pointing a gun at your windshield, absolutely. You can respond to that with deadly force, use that deadly weapon that is your vehicle, respond with deadly force, and that's going to be deadly force to deadly force, which is our justified scenario here.
Mr. Hayes, along with Joe's question, vehicle, weapon to escape violent protest in Texas. What say you?
Well, to piggyback on kind of what something Edwin Walker was saying, it's about how you use it. Cars typically not a deadly weapon. If you're my wife, yes, it's a deadly weapon. But in these scenarios, remember, even if you're justified under the circumstances that Emily was saying, using force or deadly force is a fact-specific case against usually a particular person. So most states prohibit you from acting recklessly. It's not a license to go crazy and attack people who are completely unrelated to it. Remember that your actions are going to be scrutinized. Everybody has a cell phone camera. You want to appear to be the reasonable person under the circumstances. So, as long as you're keeping it a last resort, you can absolutely respond to unlawful deadly force by defending yourself with deadly force.
Richard Hayes, Emily Taylor, independent program attorneys, joining me on our webinar for U.S. Law Shield. If you're not a member, hurry up, hop aboard uslawshield.com. Should you need them, they're there 24/7 in your state. Mr. Hayes, staying with you, this is an interesting question sent in by John M. I wouldn't know the answer to this. Do you advise land or business owners to prominently post no trespassing, no looting signs on their land?
I'll leave the looting to Emily. I'll start with the trespass signs so that everybody knows what we're talking about. When we're talking about trespass, it's two things. One, when someone goes into a place they know they're not allowed to go, or when they remain in a place after they're being told to leave. And so really we're talking about the first kind of trespass under these circumstances. If you conspicuously place signs that let people know, hey, you're not allowed here, if you were forced into a scenario where you had to defend yourself, defend another person, you would be able to point to that person and say, look, they had malintent. They knew they weren't allowed to come in here. They knew entry was forbidden. They came in here. And then let's say something escalates it to where you'd had to use deadly force. It shows that they're really coming to the problem. You're not out there seeking trouble. They're really the one coming in causing problems. So it's not a bad idea. If you don't want people entering onto your land without permission, posting no trespass signs is a good way to provide that warning.
Emily, let's get to the looting sign. Is there a point to it? Is there a legal precedent to putting up a sign, no looting on this property?
While no trespassing, I think that's wonderful. Also for people in Texas, bear in mind, you can also paint vertical purple lines on your trees. That's an oldie but a goodie. It's still good trespass notice in Texas. Also, if you just happen to be somewhere, you're on a friend's deer lease and you start seeing purple lines on trees, that's something you should be aware of. Maybe I'm crossing into someone else's property here and I would be a trespasser. However, we go to the no looting, and there's really not much of a legal point to that because unlike trespassing, where Richard discussed there being this, in many states, a notification requirement for there to be a criminal trespass, there's an intent element there, you put up your trespassing signs, looting is already unlawful. So there's no legal point to putting up the signs. I could wear a T-shirt that said "No Murder," and it would be essentially the same effect, right? It's not as though I've put you on notice that I don't want to be killed, or that I put you on notice that I don't want you to loot. It's already unlawful. A no trespassing sign is the best you can do. I would stick with that.
Staying with you, Emily, Sean B. emailed in. This is a good one. If I witness looting, like we're looking at the screen and there's looting going on at that particular store, if I witness a looting, can I make a citizen's arrest and hold the criminal at gunpoint until the police arrive? Emily Taylor.
Oh boy, I'm glad this is asked, actually, because those of us who Richard and I, when we were prosecutors together, is probably when we got our licenses to carry. We've been carrying for years. We want to be sheepdogs. We want to help not only keep ourselves safe, but keep the community a little bit safer, be there as a protective force. And so, we have this this issue that arises with our gosh, Richard, will you pick up here? I've lost my train of thought.
About citizens arrest and holding people at gunpoint, Mr. Hayes.
Here we go.
That's okay.
So, there we go. So we have this issue that arises where you want to jump in and help people, but what is your legal right, and is it a good idea? So I'll tell you, for the state of Texas, that we have this citizens arrest law that allows you to hold someone if you've personally witnessed a felony or breach of the peace. Felony, right? Some things that you'll see in a like, let's say, a theft situation or a destructive situation. Some of them will be felonies. Some of them will be misdemeanors. Do you really want to have to make that decision on the spot, knowing that you might be arrested for holding someone at gunpoint if you've made the wrong decision? Breach of the peace is our other standard here in Texas, and that's not defined by law. And every state is going to have very specific times in which you can hold someone at gunpoint. I know we all carry because we want to be protective. We want to help the community. This is one of those instances where there's no human life in danger. I recommend to all my clients who ask that they simply call the police, be the best witness they can be. Don't put themselves in danger.
Mr. Hayes, jump in on that citizen's arrest following Emily's comments. It's in the movies, be that superhero we see in the movies all the time. What say you?
Yeah, you feeling lucky? Don't do that. Don't do that. So what you got to think about, we have these overarching themes, talking about things and lives. If the only thing at risk is property, stuff, it is generally not advisable to use or deadly force, exhibit a deadly weapon, because the law and juries, I will tell you, juries do not like the idea of someone using deadly force or deadly physical force in response to a property crime generally, even when the law allows it, even when the law says, hey, you know what, under this particular circumstance, you would get an instruction for defense of property. Juries don't like that stuff. They want you to really make this stuff a last resort. And a lot of times when we're acting in defense of property, or when I see people acting in defense of property, it's not a last resort. To contrast it, if it's just property, generally not a good idea to use deadly force. Change it just slightly. Let's say you're guarding a business. You're inside. You're on the roof. You're in the parking lot. Well, if someone's trying to break in and loot the store, then that's a completely different scenario, because now it's not just stuff. We have a person in danger. You're in danger because they're coming towards you. They're attacking you. They're trying to break in. They have things in their hands. There's large groups of people. So when it's just property, it is generally not advisable to use deadly force, and the law looks not favorably on it. Juries hate it. But when a person is in danger, that's what makes the big difference, because someone at that point is in danger. So that's something that you got to consider.
Good. Mr. A, staying with you, Matt, this is an interesting one from Matt F. If I'm in a wheelchair or have another similar disability, how does that affect my right to use deadly force to protect myself? Mr. Hayes.
Yes, and I was watching the comments section, a very similar question from Thomas C. So Thomas C., this is also an answer to your question. So the way that it affects it, there's kind of two layers to it. Does it legally change your status when you're acting in defense? Some states, yes. Some states, yes, because you could use deadly force or deadly physical force in response to a forcible felony. And then we have these special categories: elderly people, people who are disabled. They usually get some kind of elevated treatment when it comes to assault. a regular assault against a regular person, maybe it's a misdemeanor. If it's against an elderly or disabled person, maybe now it's a felony. So in some states, yes, it's going to offer you some additional protection. But I'll say, even if it doesn't offer you additional protection under the law, we go back to that reasonable person standard, that subjective belief. You have mobility issues, you have you're in a weakened state, you're elderly, you don't heal as fast. Juries get to consider all those things, because when we have that objective reasonable person standard, they consider two things: the objective physical evidence, the things that you see on the scene, and then the subjective beliefs that you held in your mind at the time you're forced to act in defense. So knowing your conditions, knowing if you can take a punch or not, knowing if you can't escape, that's all stuff a jury would be allowed to consider.
Emily, jump in. Matt's question about if I'm in a wheelchair, affecting right to use deadly force to protect himself. Add to that.
Yes, no, I'm actually very excited we get to address this. I was hoping we would get to. I had a long conversation with a member just the other day about these issues. So to add to what Richard is saying, bear in mind, for any of those Texans watching, that Texas does not actually change your right to use self-defense, except in what Richard was talking about with the reasonable person standard, and they get to pull it in that way. Another interesting thing to think about is in states that generally have stand your ground, if you lose stand your ground, what that means, and there are lots of ways to lose it. I've had a client lose it by having a gun where he shouldn't have had a gun. So there are lots of ways to lose it. But if you do lose it, the general remedy is, if you have a safe path to retreat, you must take it. So if you're someone who is in a wheelchair, who is otherwise unable to retreat because of physical disability, maybe even just a temporary condition, you've got a broken leg and you're in crutches and you've got a cast, that is going to factor in, because let's say you've lost stand your ground for some reason, all of a sudden it kicks back in. You're almost at a permanent stand your ground state, because if you can say, I cannot have retreated safely, then you don't have to worry about it. So that's something else to think about. We have this elevated sort of stand your ground issue when you cannot safely retreat.
Well said. Emily Taylor, Richard Hayes, you're watching our webinar, The Law of Deadly Force and Justification During Civil Unrest. I'm Sam Malone, proud member of U.S. Law Shield. Become a member ASAP. That attorney answered emergency hotline for members is essential for you if you carry, if you're a collector or a sportsman. One more from the crowdsourced questions, and I'll stay with you, Emily. Michael M. wrote in, let's see, can I use deadly force to protect someone who is being beaten by a mob? We've seen a lot of this during the news. The mob descends on a person and starts hitting and all kinds of stuff. Emily Taylor, what do you got?
Yeah, so now I'll preface this by saying, make sure you know your specific state's law. But many, many states apply a standard of, essentially we're looking at, could you have defended your life in that situation? If you step into that person's shoes and you could defend yourself, you can generally defend that person. Now, again, some states vary, some states are very restrictive, but for the most part, generally speaking, we have that same protection, which means you see someone being attacked, being sort of, swarmed and jumped upon, you can defend that life in the same way that you could defend your own if you were the one being swarmed. So again, check your state's law. I can tell you for certain that's the state law in Texas. We do a good survey of these laws, though. It is very, very similar in many states, but make sure you know, particularly during this time, particularly if you're a sheepdog, make sure you know when you can jump in to defend that third party, but it is likely a good thing, at least in terms of being legally justified for you to be able to do that.
Richard Hayes, jump in. Our final question, mob attacking. What do you want to add to Emily's great answer?
Well, I'll say, as Emily said, we take a survey from across the United States, and generally, yes, you place yourself in the shoes of the person. Is the person laying on the ground getting stomped on by a dozen people? Would that person be allowed to draw a firearm and shoot to save their own life? And if the answer is yes, then most of the time you standing somewhere safely, advantageously, would be allowed to defend that person to save their life. So it's a tough calculation, though. When I think about those situations, it's there's a short list of people that I'm willing to go to potentially prison for the rest of my life for. So make sure that you understand exactly what is transpiring before you interject yourself, because remember, whenever you're acting in defense, it's not just about saving a life, but you're also defending yourself against a crime, potentially murder if you kill somebody. So that's one of those things that you need to think about ahead of time and prepare yourself for, because you don't want to be making those preparations after your ears are ringing from your gun going off.
Well said. Richard Hayes, Emily Taylor, thank you so much for your great answers on tonight's webinar. We appreciate it.
Absolutely, Sam. Always love taking these questions. If you like the video, make sure to thumbs up. We read all the comments, submit questions. We love talking to you folks.
You got it. Thank you. So, America, you've got a handle on the topic of the law of deadly force and justification during civil unrest. We've talked to independent program attorneys around America. What are you waiting for? Have you become a member yet of U.S. Law Shield? Do you have that card with the phone number that'll get you 24/7 attorney answered emergency hotline for members only? You need it. Plus all the other member-only offers, the events. You've got discounts, you got FaceTime with attorneys, and of course you're paying zero attorney's fees with the event that takes place when you need them, and they're experienced professionals. I've been a member for years, darn proud to be part of that U.S. Law Shield family. Go online right now, uslawshield.com/defend. If you came in midway during our webinar tonight, catch it a little later on, play it, and share it with other Law Shield members or future Law Shield members. Thank you for spending time with us in Houston, Texas. I'm Sam Malone. See ya.